Morning, and thank you to everyone who is here today to show support for fathers' rights and to support Paul Allen and Eliza. Thank you to the representatives and senators who may be in attendance today. Thank you for your time and your interest in Paul Allen's case. We hope to have the opportunity to visit with each of you about this issue while you're here. This rally is to bring to light not only the change desperately needed to reform outdated and often unknown fathers' rights statutes, but also the travesty of the adoption of baby girl G, also known as Eliza Leah Michelle Fiscus, case number 2018 AD 00307. My name is Sharon Brandon. I'm the media and event coordinator for FreeEliza, a fathers' rights organization. I am a lifelong Kansas resident and have been friends with Paul Allen for nearly 25 years. I have always thought of Paul Allen as a kind, funny, and easygoing man, but also a very private person. However, in 2018, his life took a drastic and heartbreaking turn, and now his life and his story is one to be shared with the world. At this time, I would like to bring Paul Allen to the podium so that he may share the events in his life that led us up to why we are here today.
Good morning. We're here today for numerous reasons, and while I have my own fight I am about to discuss in detail, I'm not here only for my own cause. I'm here to support fathers' rights. I'm here to support natural parents' rights. As is the case with most stereotypes that attempt to encompass an entire group of people as the same, it is short-sighted and foolish to assume that all unwed fathers are not good parents. I have the love for my daughter that any mother would have. I have the attentiveness, the awareness, the desire, and the common sense to be a very successful parent, whether I'm co-parenting or doing it all on my own. My daughter has the best father a child could have, and she's being deprived of him. She is my world before and after her birth. You ask any of my friends or family, and they will tell you that I have wanted to be a father for as long as any of them can remember. I have to say I'm not here to tear down adoption. I'm not here to express anger towards the industry. I am here to plead that the industry is in desperate need of a reboot and it needs integrity instilled back into its veins. That comes from my own experience in a fight that I'm still very much fighting, and I will explain. It should never be an assumption that because I am a man, I don't know how to or want to parent my child. Kansas adoption laws are written with a presumption that an unwed father failed in his duties if the mother consents to an adoption. My parental rights were ruled to be terminated for not providing support for the mother for the last 6 months of the pregnancy, and the court is required to consider all relevant surrounding circumstances. That requirement and the consideration did not take place. Even though I presented ample proof of the support I provided and offered in terms of monetary and non-monetary support, including transportation, offers of shelter, food, emotional support, moral support, the majority of it was either ignored or dismissed due to inaccurate testimony, with what little was acknowledged being disregarded as incidental. I purchased a house specifically to accommodate my daughter, making sure there was enough room available so that even the mother would have a safe haven at any time. 2 people on my behalf, as well as myself, testified supporting that fact, but since the mother testified I had dreamed about buying a house in that specific neighborhood, it was dismissed as if I purchased my home for myself and only myself at the exact same time that someone was pregnant with my possible child, a child that I've wanted for many years. From the very beginning of the case, I was treated as if I was lying, as if I didn't have a single positive attribute in my character or demeanor. On July 29th of 18, she began ignoring me completely. I spoke with an attorney in late July and a second attorney in August, and I had contacted DCF twice. I even contacted the hospital to see if there was anything I can do to be involved, and they said no, there was nothing. Both attorneys had said that I couldn't do anything until the child was born to assert my rights, even though that was inaccurate. Contacted DCF. One of the reps at DCF actually suggested breaking HIPAA laws in order to get access to the mother, which I did not do, of course. During the trial ruling, the district court judge said I was mean, self-centered, and sarcastic towards the mother, even though I submitted over 3,500 text messages that show at least 200 different examples of positive statements I've made to her in many different mannerisms. That court did not give an example of this accusation, though they clearly ignored the numerous positive text. The Court of Appeals stated in their decision that we had a toxic relationship. There is nowhere in the statutes that says a parent's rights can be terminated because they argue with the other parent from time to time. Meanwhile, the mother was treated as if she couldn't tell a lie, even though the majority of her testimony was just that. She was never reprimanded because of her manipulation or deceit during the pregnancy, before or after. She was never reprimanded for purposely being induced a week ahead of schedule in an effort to exclude me. And when she ghosted me at the adoption agency's counsel, she was not held accountable for it. I was held accountable for it. Behind the irrational statement that I could have still found her, as if I needed to have a stalking order placed on me to secure my rights. They even said I could have mailed money to her place of work. We only had 2 friends in common at that point, with a third as an acquaintance. She wasn't speaking to either of the 2 friends, and the third person, who didn't really know any of the situation, remained neutral. It is ridiculous to deem her sudden refusal to communicate as somehow my failure. The numerous hurdles placed in front of me after the birth of my child were even more ridiculous. The adoption attorney took posts I made on social media, which were clearly in a light and joking manner, and submitted those as evidence, as if they were somehow indicative of how I would parent my child, or that I'm somehow a bad person. Why their own laws and statutes were either ignored, misinterpreted, or incorrectly applied, common sense was abandoned. I do not have any sort of criminal record. I very clearly wanted my child from day one. I was very clearly prepared during the pregnancy and continued preparing to parent after she was born. Even though I would obviously do anything for my child, such as drive through a blizzard or abandon my car on a highway to make a 4-hour trip on time to spend only a few hours with her in a hotel room, I was abruptly cut off from her. My child's best interest is to be with her natural family. Even though my trial attorney did an amazing job and every single witness's testimony ultimately showed that I was fit to parent and I was not apathetic in any manner, the court's ruling completely ignores the Supreme Court's previous statements that when a natural father assumes his parental responsibilities, the right to raise his child is entitled to constitutional protection. Even after the baby girl P case, in which the Supreme Court stated we do not find it in the statutory scheme a legislative call to make the assertion of parental rights a Herculean task, and the CL case, which cited that very quote, a Herculean task is exactly what was imposed onto me. Those 2 cases also stated the preservation of a father's relationship with his child is the starting point of the termination proceeding, not the finish line that a father must labor to reach. Another bullet point completely ignored by the Sedgwick County probate judge. Not only did I have to jump through numerous hoops based simply on the mother's empty accusations, not only did I have to repeatedly leave my child with strangers after only being allowed visits with her as if I weren't her father, not only was I treated as if I had no right to even be there in the first place, not only were the majority of these positive things I did and was doing ignored, where one little mistake was blown out of proportion as if it were an unforgivable sin. Not only did the adoption attorney utter slander towards my character over and over again while referring incorrectly to events that had no direct connection to the issue at hand, but there was also an extreme lack of decency in ordering my trial attorney's legal fees to be my responsibility after my rights were unjustly terminated. The mother and I had a brief relationship that had ended before the pregnancy was discovered. Still, I was there for the mother the entire pregnancy at the level the circumstances would allow. I wanted my child from the very first moment the possibility of her being mine arose. I should not have to be still fighting for my God-given right to parent her. I was underhandedly betrayed by the mother, whose mental health and fitness in regards of making such a giant and devastating decision have never been questioned. Every step of the way, the adoption agency's attorney has manipulated and twisted the truth to put me in a negative light to the point of absurdity. Repeatedly, he has stated I failed in my duties when anyone who has any knowledge of this case and does not have a financial interest in my rights being terminated disagrees. As I previously mentioned, during the trial there were many incorrect statements made to put me in a negative light that had nothing to do with the case at hand. 3 different professionals, and I do use that quotations around those words, that were employed by the attorney made appalling and false statements to put me in that same negative light. For example, the very first time I was able to see my child, the resource and one of these hired guns were in the same room. That individual stated in a report that no one even requested that I had said I could not do this every day. The resource went along with it, even though any person with any common sense would see that my actions in that statement do not coincide. Another one of these hired guns diagnosed me with a disorder, that I do not exhibit a single trait of the qualifying criteria I have, and then made statements about my future parenting as if that were simply appalling and easily discredited. I shouldn't have to explain to anyone that this person cannot see into the future or know what kind of person I am based on only a few hours of interaction. I had to take this evaluation months after the initial petition determining my rights was submitted, a petition that made sweeping allegations with zero specific facts to back any of them up. After my attorney submitted a bill of particulars demanding to know the exact allegations I would need to defend myself against in a trial, they failed to meet the appropriate deadline for an answer. When I filed a motion to dismiss the case due to this failure, the court simply allowed them even more time to submit an amended petition with facts that were required to have before the first petition was submitted in the first place. One of the amended accusations was that I had somehow abandoned the mother by being self-absorbed, with no proof available to back it up, as if that's something that can happen in the first place. Despite all of this, despite the attorney harassing my attorney at every chance, despite him and the resource treating me with a complete lack of respect, despite the long commutes to see my child for only a few hours at a time, despite the feeling in my gut that the court was already completely on their side, I persisted as I persist today. The evidence that I did what I could within reason and in light of the circumstances should have put the ruling overwhelmingly in my favor. Adoption statutes that are to be strictly construed in a favor of maintaining the natural parents' rights, when the consent to adoption would be not required if those rights were terminated. In my fight for my daughter, they were not strictly construed in favor of maintaining my rights. In fact, quite the opposite took place. I didn't fail to provide the proper support, and case law states I shouldn't be held accountable for offers not accepted. The Court of Appeals had even admitted in their decision that father made several other offers of financial help the mother did not accept. He offered to help her pay a $2,500 security deposit for a new apartment she was considering, and once when she needed a ride and I was not available, I offered to pay for an Uber because I could not leave work. Mother said she declined the offer because it would cost too much, and she knew that she would find another way to go where she needed to without that. The facts have been and still are grossly manipulated at every chance to make it look as if I chose not to participate in any manner. At this time, I had previously submitted a petition for review to the Kansas Supreme Court in December. The facts have also been manipulated to make it look as if she was in dire need at any point during her pregnancy. The law states that I am supposed to provide support even when not needed, even though I was constantly checking in on her and about her well-being and was available to offer her anything she needed. It's been stated as if giving her money for her own discretionary spending would somehow have shown my commitment to parenting. I was there for her the entire time, and after she was coached to start ignoring me, my natural response was to back off. And that natural response has been used against me as if I abandoned her in some manner. The attorney has submitted a response to my review, and in this response it appears logic checked out during the first paragraph. He says it doesn't make sense for biological fathers to have their children handed over to them. He argues that biological fathers, not knowing of the statute's vague requirements of an unwanted father's pre-birth, is perfect and doesn't need any amendments. He even says that though I was not found unfit, it doesn't make me magically fit, as if there's a third option. I read this sentence probably a dozen times just to make sure I wasn't missing a word that made it all logical, but I was not. Wrong in that assumption. During all of this, the mother gets to communicate with and see our child, while I have been completely blocked out for no reason at all. As soon as the trial was over, the adoptive resource had blocked me on every social media available, as if I were an intruder, as if I were a stranger. as if I were somehow in the wrong for wanting to parent my child. Based on the exact wording of the statute, a statute I was not even aware of until this case, I satisfied the requirements by my own doing, but was still thwarted by the court system. It felt like from the very beginning that the court was never impartial. It seemed that it had already been determined my rights would be terminated before I even stepped foot inside the courtroom for the first time. Considering how the court took the mother's side despite every single empty attack being shot down, it absolutely calls into question certain parties' integrities and their intentions. They filed a petition for adoption without any facts to back up those allegations, and when we forced their hand, they failed to deliver on time. They were allowed access to all of my finances. They were allowed to intrude any records, mental health, or anything otherwise. And by the time the trial had ended, I had been called everything from a drug addict to a narcissist to someone with a crippling codependent personality disorder, which completely contradicts the previous accusations. When the resource learned how involved I was and how much I loved and wanted my child, they should have removed themselves from the equation with integrity and kept on their search to find a child who truly needed them. Instead, they helped conspire to keep me out of my own child's life, and even worse, to keep her out of mine. They didn't have any problems with attempting to hurt me or attacking me, but that I can handle on my own. However, to know that they have put damage in place for my daughter years ahead of time upsets me immensely. It is a parent's instinct to want to protect, nurture, teach, and love their children. Knowing that if this travesty is allowed to stand, I won't be allowed to be there for her, that I won't be able to perform my duties and fulfill my responsibilities, though very much wanting to do so, it tears me up. Knowing she wouldn't be told the exact truth about what's happened until maybe she's 18 or older is very destructive and concerning. She won't be told she will not be told her father fought for her with everything he had just to have the rug pulled out from underneath him and shut out like a criminal. She won't be told I've spent nearly a year so far crying every single day, missing her every single day. She will most likely be told one thing, and that's that I didn't want her. The selfishness and lack of integrity involved in this case has deeply offended me, as it would offend any parent, as it should offend any parent in attendance today. Fathers like the father I am shouldn't have to go through what I'm going through. It should be common sense that a fit natural parent who has the desire, the wherewithal, and the resources to raise their child should be able to. Unwed fathers, when contesting adoption, are put to a higher test than any parent involved in a sink case would be, and that is irrational. It is ridiculous to demand more from a parent who has not abused or neglected their child than from a parent who there is probable cause to believe has. The adoption attorney's answer to this is that the parent who has neglected or abused their child has already established a relationship with that child. Think about that. The adoptive couple are allowed temporary custody of the child in a contested adoption and throughout the proceedings. The parent contesting it is only allowed a few hours at a time to be with her or their child. Why is that? I am not a criminal, I am not a monster, but I was treated like one. I was only, quote unquote, allowed to spend a total of 56 hours with my daughter, and my heart has ached for her ever since. With as many children as there are out there whose parents have abandoned them or have been removed from their parents' care, and their parents have failed to take the appropriate steps to regain custody, it makes absolutely no sense to purposely and to tactfully attempt to prevent a fit parent who wants to raise their child from doing so. My child should not be with these strangers, where she is placed before I was even aware of her birth. The attorney shouldn't be of the mindset to thwart the father who seeks to raise his own child. Unfortunately, what he considers integrity and common sense are not the same as what most people consider those. Adoption attorneys and agencies definitely shouldn't have that control that they have during any contested adoption proceeding, especially with that mindset. This attorney has written in a petition and submitted it to the courts that he thinks it makes no sense to give a child to their natural parent based on biological link alone. That sentence goes against the very Constitution of this country in so many different ways. If a natural parent, which is a wording I dislike immensely, wants to raise their natural child and are not legitimately unfit, it is their God-given right by nature, by the Constitution, and by common sense. Under the circumstances of my situation, I absolutely did not fail to fulfill my pre-birth duties. The District Court and then the Court of Appeals are who have failed. They failed at performing their duty of assuring the law is followed accurately and carried out as it should be. They have failed miserably to do equal right to the poor and to the rich, to serve justice and to serve truth. Instead, they have contradicted themselves in each of their rulings and opinions, ignored facts, affirmed incorrect statements when proof otherwise was available, and even added their own spin to the inaccuracies. Where they should be heroes, they are not. It worries me to think of how many times they have dropped the ball. On March 3rd, it will be a year since I have seen her, been able to hold her, been able to love her. I've missed her first steps, I've missed her first word, and these precious moments have been stolen from me. They have convinced themselves they've done nothing wrong. This is how adoption has been set up. This is how contested adoptions have been set up for a long time. A change is well past due. Fathers are parents too. There is ample evidence in today's world that fathers can be just as successful as parenting as mothers. They can love their children just as much. They can and will do whatever they need to in order to provide for their children. When these laws aren't updated with an appropriate speed to match the constant evolution of society, they have more and more of a chance to cause harm and even destroy the lives of law-abiding, good-natured American citizens. They are laws that go against everything in the Constitution and what it stands for. They have allowed so far for my daughter to be deprived of her very loving father and her very loving natural family on both sides of her father's and mother's. And this cannot stand. They have been allowed to run amok over the state, lying to unwed fathers, breaking unwed fathers, lying and tricking confused and or still heavily medicated mothers into giving up their children and their rights, and simply to make a profit off of their broken hearts. Adoption should be reserved for children who need loving homes. Adoption should not be used to separate children from natural fathers or mothers who are capable and desire to parent their children. Adoption is supposed to be a beautiful thing. It's supposed to be a shining light, a salvation for these children who desperately need it. But unfortunately, these people have made it very ugly. We are here today to have the court advocate for more than just my case. This is about more than just us that are here today. It's about more than even just fathers' rights. It's about equal rights, equal parenting rights, the literal meaning of the word equal. The mothers and fathers are both equally important to a child's upbringing, and neither sex should be demonized as a whole because of poor, selfish decisions made by a few. In closing, I and we as a community have a very important suggestion. The Family Law Advisory Committee recommends changes to the family law in Kansas as legislators review the changes and make updates based on the committee's recommendations. That committee is made up of probate judges who decide these court cases and pro-adoptive family lawyers who only work for the adoptive families. There should definitely be some representation from the community on this committee. Someone who does not stand to benefit financially from allowing adoptions to take place unethically. This has impacted my life immensely, turning it into a nightmare, while my adversaries and complete strangers profit off of that nightmare. I cannot be alone in this. These people who profit off of these adoptions, especially like the ones I'm personally dealing with, should be ashamed of themselves. The mother of my child should be ashamed of herself, no matter how she has irrationally justified this horrid action. I'd like to take this moment to acknowledge all the support I've had throughout all of this, overwhelming support from my friends and my family, from the mother's family, from anyone who has become aware of this and has shown empathy in any manner. I can't find the words to properly describe how grateful I am to each and every one of you. Thank you for being here, and I sincerely appreciate it. Thank you.
Thank you, Paul Allen, for sharing your story so bravely with us today. I know this has not been an easy process for you, and it makes me very emotional. I would also like to apologize for mispronouncing Eliza's middle name. It's very cold out here, and I'm going to blame it on the weather. I would like now to share a poem that I wrote about this case, entitled No Consideration. Here we are today at this demonstration. To get to this point took much preparation. Birth fathers raising children, there should be preservation. Being a father to Eliza is Paul's true motivation. With the child's birth mother, there was a separation. She cut off all contact, there was no communication. The way she treated my friend, well, that's pure manipulation. While pregnant, she taunted, "It's not your relation." She induced labor early, no 40-week gestation. Baby Eliza, their child, what a beautiful creation. She gave Eliza to strangers with no reservation. Paul's wishes ignored with no consideration. Can you imagine yourself in this sad situation? Tests proved he was her father. It was pure validation. Now he had to fight the Adoption Association. Greedy lawyers selling babies with no hesitation. They subpoenaed his records, searching for information. Allegations made against him were pure fabrication. An unwed father being unfit, what a terrible classification. This stigma affects millions all across our nation. To say that he'll fail, it's just pure speculation. Awaiting the trial, there was no accommodation. He traveled hundreds of miles for a 2-hour visitation, spending time with his child under full observation. He wasn't a criminal, but he was put on probation. Put yourself in his shoes. Can you imagine the frustration? On pins and needles while courts made determinations. False testimony given with untrue implications. When he heard the verdict, total devastation. Terminating his rights with pure annihilation. Losing Eliza was not his expectation. The pain wrecking his heart, what a horrible sensation. For Paul's legal rights, they had no consideration. Paul wants his child. Can't you sense his desperation? Of his parental rights, there should be a restoration. We have hope for the future with new representation. Laws are written for a reason, not for your interpretation. At this time, I would like to invite our next speaker to the podium, Mr. Andy Daniels.
Thank you. Boy, it is chilly out today. Well, I'm glad to be a part of this. I have a special feeling for being here. My grandmother was a Kansas state senator for 12 years between 1984 and 1996. And I remember being 7 or 8 years old, going right into this building and sitting in a chair. I don't know what 7 or 8-year-old gets to sit in a senator's chair, but that was pretty darn cool. She fought for a lot of rights and a lot of causes that weren't necessarily popular at the time. Even though she was a Democrat, she was staunchly pro-life, and she held off abortion and the death penalty in this state for 12 years. She told me about the politics here, and she told me that sometimes it was difficult but very rewarding. So I'm glad to be able to stand here and speak about a cause that I feel is very important and underrepresented. A little bit about my story. I actually have some history with the family law courts here in Kansas. When I was young, my parents were unwed. They were in a similar legal situation. They did not marry. They had a baby, which was me. And my dad lived on the West Coast, and my mom lived here, and her family was here. So that's where I grew up, right here in Wichita. Well, not here, but I grew up in Wichita, Kansas. And it wasn't until I was in about 5th grade, when I was 11 years old, that I started to feel the pain of what it was like to not have a dad. And I had some trouble at school with some kids, and it was very hurtful And I remember breaking down one night, and I said, I just want to call my dad. So my mom, we looked up his number and we called him and had a conversation. And at that point, my dad realized that he should be a part of my life and I wanted to be a part of his. And what happened then was a whirlwind because the courts got involved and none of it made any sense to an 11-year-old. And I'm sure none of it made sense to my mom and none of it made sense to my dad. And after long conversations with them as an adult, I can understand that the family law courts did not make sense to them. And a lot of things have made some progressive changes towards equalizing the rights for both parents in the state of Kansas since, gosh, I don't even know when that was, 1999. So a couple years since then, right? But we need to do more. That process for me was quite, even though I was 11, I was aware of what was going on. And you know, it's interesting, ever since I was a kid, I've had family members tell me, you walk like your dad, you talk like your dad, you make arguments like your dad, you look like him, you have mannerisms like him. It's the weirdest thing because honestly, I haven't spent much time around him. As a child, I was able to visit for several weeks at a time, but not the kind of extensive time you would think that somebody would need to adopt mannerisms and patterns of thinking and whatnot. So for me personally, it is very clear that there is simply a genetic link between me and my dad. And you'll ask any of my family members that know him, and they can tell you that's true. Unfortunately, in our country, in our society, the courts have decided that fathers need to do more than just present a biological link. This so-called biology plus doctrine. And that's what we're running into right now, is the fact that the laws that are as they're written and the courts, the way that they determined, decided that the dads had to somehow pass some measure of test beyond providing the genetic material. You know, when my mom was pregnant with me, I've heard stories. There was immense pressure from my family members to adopt me out. She was an unwed mother. It was 1987. She was unwed. The prospects weren't great. She was young. She hadn't finished college quite yet. So the theory was you should give the baby up to someone else who's more capable, who's more willing, who has more finances. And the logic breaks down right about there. And I'm so glad my mother did not adopt me out because I'm exactly glad for the way I was raised. And I'm sure there are lots of stories of adoptions that are very successful and that it was the right thing to do. However, I'm glad for the decision that was made. I do recognize the pressure that was there. And that pressure is coordinated and mounted in the adoption industry. And it's very carefully constructed between all of the parties. And it's all held together by a veil of secrecy. No one is allowed to know what goes on behind closed doors. Everything is secret for the protection of who? The mothers? The fathers? Definitely not. The babies? Maybe, but not really. Most adoptees want to know about their history and about their family when they grow up. Not even before then. When they're teenagers, they'd like to know. You know, you have a middle school project. Oh, tell us about your family history. Yeah, what are you going to do? Right? And so anyways, the pressure to adopt was there with my mother. And she declined. She was able to escape that pressure. But I know of several mothers right now, today, in this state, who are under pressure by the adoption industry. And this is sometimes overt pressure and sometimes it's implied pressure. If you give a mother a bunch of grocery gift cards as a social worker working for an adoption agency, and you give her a bunch of grocery gift cards, do you really think that there's not a sense of obligation created? If you start giving her rides to doctor's appointments and you start being her friend and being available to her all the time, is there not a sense of obligation created? And sure, maybe it's good, maybe it's not, but let's think about the dynamic here. You have a couple who has had a chance to amass wealth. They haven't had kids. I've got 5 kids at home. I know it's expensive, right? We didn't have kids, dang, I'd be rolling in it. But the couple comes to the adoption agency and says, we want a baby. Tell me that that's not how it happens. They say, we want a baby. The adoption agency says, well, this is how much a baby costs. And if we look at the economics and the supply and demand, if there were only 18,000 private adoptions that actually were approved in 2017, according to the Donaldson Institute for Adoption, but there are over 1 million families waiting to adopt, you tell me who gets to buy and sell at that point. The adoption agency needs to make their clients happy. There is enormous financial pressure at every level, and it all bears down on the mothers and fathers. And usually, as we see in Paul's case, the fathers aren't even allowed to be involved. So you have a mother who feels like she has no resources. You have a mother who feels like it's one of her only options. You have a trend of no abortion in this country, and this is not this rally for that, but look at all the factors. The mother says, my only choice is adoption. I have no resources. I don't know if I can get a job. I don't know if I can get a house. My family members don't want me to have this baby. What else is she going to do? She's going to go to the adoption agency, to the social worker that's become her friend. And the stories that I've found of mothers who are not even 12 hours post-birth, which is the limit in Kansas, if you can imagine that, such a short time frame. And they are getting coerced, they're getting cornered. The lawyers are coming in and saying, you must sign these papers. We will charge you with criminal charges if you go back on your word. Could you imagine? So you put them in an untenable position, and then you lock down the process because of permanency. And you want to say, well, the babies need to have permanent homes. But you allow unethical practices, you allow coercion, you allow lawyers like Martin Bauer to construct a complete framework to shuffle children between states. He has agencies in Colorado, Utah, Oklahoma, Kansas, Georgia, and he can shuffle the babies and the prospective parents in between any of those states. Not one, it would take an army of lawyers to untangle something like that. And I hope that the Kansas legislature can step up and say that Kansas is not a state for buying and selling babies. Kansas is a state that will find a home for children, but not a children for homes. Learning about adoption, I can tell that there's a very rosy picture painted by the adoption industry. And I am not anti-adoption, but if you go to any adoption agency website, I challenge anyone here listening, I challenge you to go to adoption agency website, go to the section for prospective parents who want to give their children up, and compare that to the language of the section for prospective parents who want to adopt. You will see grave differences. For example, on one site that I found, for the natural mothers, as we're not allowed to call them anymore, we're supposed to call them birth mothers, it protects the adoptive parents' feelings. I might be being hard about this, but somebody has to say, wake up, there's some very wrong things being done here, and even though a lot of it is right, to do it this way is not the right way to do it. I don't want to raise children in a society where it's okay to steal children from parents who want them. To complain that dads, oh, we don't have fathers in this country. Where are the dads? Where are they? Why won't they step up? And then when you have someone like Paul step up and say, I want to be a father to this child, you block him at every turn. So which is it, America? Do you want fathers or not? Because if you do, change the laws and make it easier for fathers to step up and be fathers. Look at the other side, though. Look at the side of the birth parents versus the adoptive parents. They will tell the adoptive parents that open adoptions are encouraged but not required. They'll tell the birth parents, though, that they can have an open adoption plan, and they'll make it sound like you can actually have an open adoption that's enforceable, when in reality, most states don't honor open adoption contracts in the slightest. If a birth mother or father had an open adoption and they wanted to enforce that, they would be out of luck, and they would usually find that out once it's too late. Where we should be at is we should be providing support and resources for mothers and fathers who feel like they don't have an option, who feel like their only choice is adoption, abortion, or abandonment. Those are not the only three options. There are plenty of services in this country. There are plenty of people. There are plenty of organizations. And there are plenty of ways that these parents can get support. Now, if you're looking to adopt, and if you're going to be putting up $30,000, $40,000, $50,000 to buy a child, and that's what I'm going to call it, because the onus is on you. And I'm going to speak to you. Hopefully, one of you that's looking to adopt hears this. You must do your research, and you must insist in transparency in the process. And it is on you to insist to the best of your ability that there are two parents who made that child, and both of them need to be given adequate and ample opportunity to participate and to agree to the process. Just a little bit about the specific case that got me involved. First off, I am so proud of Paul for standing up here and doing what he's doing. This has been a 2-year process for Paul. Maybe even longer, right? 2 years? Yeah, something like that. If you could imagine having a child and having to fight for them for 2 years, not being able to see them, being given very limited amounts of time, it would break most people. Most people would tap out. They would say, I want to forget about this. You know what's really rough? What's rough is that it's almost like somebody who's performed over 3,500 adoption cases and only lost 22 contested adoptions in their career. It's almost like they understand how emotionally intense this is for the parents, and they know that if you can just wear them down long enough, the parents want to tap out. Most parents wouldn't be able to sit there and watch and be able to have their hands tied and do nothing. I think it's a totally natural response to want to say, I give up, I'm going to put this behind me, I'm going to disconnect from this. And then they turn around and fault them and say, well, where are these parents later? Well, I'll tell you what, you traumatized the hell out of them, and now they're trying to move on from it. That's what happened. But I'm really proud of Paul for sticking with this and taking this to the top, because the record's going to show at every level that he was not going to stop. And when Eliza is 18, when she's 19, and she goes to look at the record, there's not going to be anything that anyone can say that's going to make it different. And so the people in her life are going to have to be held accountable at some point. The case that brought me and Paul together is in Wichita, and it was about a year later from when Paul's case started. Now, in this case, it was an 18-year-old man, and his girlfriend who was 18, almost the exact similar situation. They were on and off again. She got pregnant. He didn't really know until a couple months in, and then he did what he could to support. Took her to doctor's appointments, bought her groceries, got her some work clothes, did what he could. Who in their right mind would think that you need to set up a separate bank account for the mother? Have you ever tried to open a bank account like in someone else's name? The courts and the legislature says, well, you need to open a bank account in the mother's name even though she doesn't want it. Okay, Joe Schmo, let me go open a bank account in your name. What bank is, hey, Mr. Banker, I want to go open an account. No, I'm not that person. No, I'm not related to them. No, I'm not married to them, but I'm going to open a bank account in their name. I'm pretty sure that's illegal according to the Patriot Act. So the courts are literally expecting fathers to do illegal things in order to keep in contact with the mothers. It's insanity. No one in their right mind would think that as a father, when you know that you have a child that's being gestated, that you have to do more, that you have to do like a way high bar more. But that's what's required. That's what's been asked of Paul. That's what's been asked of this other case that brought me and him involved. You're expected to pay exorbitant amounts of money. You're expected to meet a level of fitness that I don't think anyone can actually figure out what it takes to be a father that wins a contested adoption case. I don't know if anyone knows. So if the Kansas State Legislature could please clear that up for the courts, they're clearly confused and they need some guidance. This case, unfortunately, is ended now, that brought me and Paul together. However, the matter at hand, whether or not fathers should be allowed to be involved. Once the baby's born, it took two parents to get there. One of the things that we should have is more time. Parents need more time. I just had twin babies in the hospital 16 days ago. And I can tell you, the 3 or 4 days that they were in the NICU and the 5 days that we were in the hospital and the days that my wife was recovering, I could not have made legal decisions. There's no way. There's no way that any reasonable person should be asked or expected to make binding legal decisions when they're in the rush of the hospital, birthing a baby, taking care of a baby, waking up every 2.5 hours to feed a baby, change their diapers. That's unreasonable. So to say that a mother should only have 12 hours, I know, this is another kind of point that I just remembered. A lot of people seem to think that the mother has a chance in Kansas to reverse her decision. However, the relinquishment in Kansas is permanent and final unless she can prove beyond a shadow of a reasonable doubt, with clear and convincing evidence, which is the highest legal standard, that she was coerced. So pretty much no mother has ever been able to prove that she was fraudulently coerced into an adoption. That's never possible. It hasn't happened yet. So best of luck on that. If you guys can change that, that'd be great as well. But it's amazing to think about. Those of you that have had children and you've been through that process and been in the hospital with your kids, you barely have time to figure out if you're putting the right name on the birth certificate, right? To sign a permanent legal document, if you had an epidural, it doesn't even wear off for 12 hours. Like, you might still be under the influence when you're signing those documents. And we've had reports and hearsay, basically, of lawyers going in and making mothers sign the documents while the baby's still fresh out of the womb. The ethical implications of adoption are enormous. And I'd just like to point out, even though it's not the necessarily this case at hand, international adoptions have come under fire recently, and rightly so. In fact, I think there's been about 16 countries around the world that have outright outlawed adoptions, foreign adoptions. Places like Haiti, Uganda, Ethiopia. Because in their cultures, the idea that you would just take someone else's child instead of help the family is so ridiculous, and it's so foreign to them that they didn't think they needed to make a law outlawing taking someone else's child. And for some reason in America, not only have we decided it's okay, but we've decided it's okay to allow financial incentives behind it, and to proactively use legislation to block parents and family members, grandparents, aunts and uncles, from participating in that child's life. I will tell you, if you go around the world, places like Haiti, India, Uganda, they have a culture that says we will come around as a community and we will invest in this child's life. If you're an aunt, an uncle, a brother, a sister, a cousin, you can participate in this child's life. So I would almost say, if you want to adopt privately, why don't you just adopt the family? Adopt the mother that's struggling, the dad that wants to get a job. Become a part of their life instead of taking something from them. Do that as the adoptive. Don't spend your $50,000 on lawyers. Spend it on the family that needs help. I'm pretty passionate about this. I'm very sad about the way the case went down that brought me and Paul together. But I'm very hopeful for Paul's case. I'm very hopeful because I can recognize the sentiments are changing. I can recognize that our country's realizing that we need to do more to preserve families, and that we have a different definition of family than we did 60 years ago. Just because you're unwed does not make you unfit. Just because you're two males does not mean you can't parent. Just because you're two females doesn't mean you can't parent. Just because you're a grandparent or a sister or a cousin, maybe you're a group of friends and you're taking in a kid whose parents died. I don't know what the situation is, but I think we can expand our cultural definition to a greater definition of family. And maybe we can wipe out some of the financial incentives. I found a report about the adoption industry. And if you think that all of this is just, la-di-da, that's all well and good. It doesn't pertain to me. That's fine. But you're raising kids right now. If you have children, you're raising children right now. And I want to encourage you to think about the world that they're going to grow up in. And the reason I get passionate about a topic like this is because I have 4 daughters now, and I have 1 son. And if I get into this situation, I will be encouraging my daughters. I will be helping them in whatever way that they need. And I can promise you this, Martin Bauer, if my son turns 18 and his girlfriend puts his kid up for adoption, you better watch out, because I'm going to have all my ducks in a row. So will he.
Sorry. Upset about it.
Whew. Thank you, Andy. Very passionate about this cause, and that comes across very clearly, and you gave me chills, quite frankly. We truly appreciate you taking the time to come here today to speak on behalf of fathers' rights and coerced adoptions, which is definitely something we're all passionate about. At this time, I would like to tell the story of Paul Allen and AG and how this case came to be. Whew. Prior to 2018, Paul Allen was a single man, never married, with no children. Although he has always wanted a child, this life-changing event had not transpired for him just yet. For some time, Paul Allen resided in an apartment, maintaining his own expenses, responsible only for himself. He spent his free time playing guitar and singing in a local Wichita band. There came a time, however, when it was decided his mother and grandmother would reside with him, so they all rented a home together. Paul Allen had hopes of owning his own home someday, but that time had not yet come in his life either. He was working full-time for an insurance company and had a second part-time job as a delivery driver at a local Pizza Hut. It was there that he met a woman with the initials of AG. Paul Allen and AG began casually dating in September of 2017. They had essentially an on-again, off-again type of relationship through January of 2018. During one of these on-again time frames, January 1st, 2018 to be precise, Eliza was conceived. Paul Allen had heard rumors amongst coworkers and friends that AG was pregnant. When inquiring with AG about the possibility of her being pregnant through text messages, their main form of communication, it was finally confirmed on February 14th that yes, she was indeed pregnant. In January, however, he discovered that AG had been intimate with at least one other man during the week the child was conceived. So he had no way to know for sure if he was the child's father. Still, he moved forward with the presumption that he was going to be a father, especially after the mother had a sonogram in early March and declared on March 14th that Paul Allen was definitely the baby's father. Several months later, in July to be precise, he learned that AG had also been intimate with a third man during the time the baby was conceived. Naturally, he questioned AG about whether or not this was actually his child. There were times he became very frustrated over this and made his feelings known through text to AG, which I feel was only human. Wanting a child, having that wish finally come true, yet having to deal with constant doubt and disappointment, it would make any man feel desperate for confirmation. Paul Allen panicked any time he learned this may not be his child. There were approximately 3,500 text messages sent and received between Paul Allen and AG over the course of roughly 7 months, speculating about the pregnancy, confirming the pregnancy, discussing the likelihood of him being the father and the chance that he may not be after all. Paul Allen truly wanted to be the father of this child. Some days the mother would say with no hesitation, "You are the father." In his excitement, he began posting to his social media platforms for all his friends and family to see, "I'm going to be a daddy." Then, out of nowhere, the mother would change her tune and essentially say, "It's most likely not yours." In fact, on July 1st, she messaged him and said, 33% chance she is, 66% chance she isn't. This was also during the period of time that AG suddenly decided that Eliza would not carry Paul Allen's last name after she was born, something that had already been decided in a text message on April 11th, to which the mother had declared, "I love it," in reference to giving the child the birth name of Eliza Lee Michelle Viscus, with the middle names and homage to both Paul Allen and AG's mothers. The roller coaster of emotions Paul Allen felt over the course of the pregnancy was enough to break a lesser man. One moment, pure joy and pride. The next moment, total heartbreak, fear, and disappointment. Between January and July, he became completely immersed in preparing for the baby's birth. He made it clear that he was anticipating being a father and provided several different types of support to AG. He attended 6-week parenting classes, helping to earn the couple $400 worth of baby supplies. He cashed in his 401 retirement savings, taking an early withdrawal tax penalty so that he could purchase a suitable home for the child to be raised in. He was, as stated before, involved in naming the child. At first, it was Thomas for a boy, Eliza for a girl. He attended all doctor's appointments that AG would allow him to be included in. When AG was evicted from her apartment for not paying her rent, she moved into a boyfriend's home, who made it clear that he had no interest in raising this child with her or having a child reside in his home. When the relationship with the boyfriend faltered, Paul Allen offered to let her live in his home, even though they were no longer together. Paul Allen would ultimately open up his home to her 3 times over the course of the pregnancy. AG would decline every offer. It should be noted also that while AG lived with her boyfriend, he paid all of the rent and the utilities at the home, so AG had no cost of living while residing there. She was on state assistance, receiving cash and food stamps each month, as well as WIC, or Women, Infant, and Children, assistance for food and milk. She also had state-provided medical insurance, so there were no medical costs incurred during her pregnancy or the birth. When she declined Paul Allen's offer to move into his home, he offered to allow her to store her belongings there so that she would not have the cost of storage rental, which she also declined. He also offered to pay her deposit on a new apartment and provide a reference for her, which she declined. She chose instead to stay in temporary locations with any family members that would allow it, clearly providing an unstable situation for herself and their unborn child. He also allowed AG to use his address as a mailing address to save her the cost of a P.O. box, as she had no steady residence during her pregnancy. AG had use of 3 vehicles during her pregnancy. However, when they were not operational, Paul Allen offered transportation several times and even offered to pay Ubers for AG when he was unable to leave work and she needed a ride. Sometimes she took him up on these offers. Other times she declined. To help AG stop smoking during the pregnancy, he bought her a vape pen. When it broke, he helped to get it repaired. When her phone was about to be disconnected for non-payment, he paid the phone bill, as it was his only source of communication with AG at that point, and he knew she needed it to also be able to contact her doctors or family at any time. He provided several examples of emotional support during her pregnancy in those 3,500 text messages, including comforting AG when she was saddened by the thought that her own mother would not be there to see her new grandchild when she was born. He helped the mother to pick an insurance plan, reviewing with her the benefits of each plan available. He began to collect articles of clothing and toys to prepare for the baby's arrival. They also discussed the ways in which they would co-parent baby Eliza, how they would spend their time separately and together with the child. In March, after being told the child was definitely his, Paul Allen discussed with AG the importance of putting everything in writing, the decisions that they had made together to protect and assert his natural and legal rights to his child. The mother at that point decided that it would be okay if it made him more comfortable. They discussed an upcoming sonogram and a possible gender reveal party, with Paul Allen clearly advising the mother that he wanted to be present at the sonogram to learn if the child was a boy or a girl. The mother responds, "Definitely." Paul Allen tells her, "You know, I'm already so ecstatic about this kid, it would break my heart if they were wrong." She replies, "I know, they'd have to be really dumb to be wrong though, going off the sonogram." They soon learn that the baby is going to be a girl. On April 5th, she texts, "We've got a lot of stuff to work through emotionally, but we can do it. We have to do it. We don't have a choice." This is during the time frame that they have decided on naming the child Eliza Lee Michelle Fiscus, and the baby has already lovingly earned the nickname Elm, based on her initials. A week later, April 12th, AG is texting Paul Allen, assuring him what a good dad he is going to be. It is during this month that arrangements are made for the parenting classes that they will attend together. As the pregnancy progressed, however, things began to change unexpectedly. By the end of April, the 29th to be exact, AG sends Paul Allen several texts admonishing him for wanting to speak to a lawyer and put some type of protection in place to assert his parental rights. She advises, "I'm not particularly fond of you speaking to a lawyer by yourself." She shames him for wanting to put the baby on his insurance when it's born. She advises him that for the good first year of her life, Eliza won't be going anywhere without her, or without her knowing explicitly where she is. She tells him she's annoyed by him, and he's stressing her out, always wanting to talk about the baby and lawyers and agreements. Fast forward to June 2018. Paul Allen tries to discuss getting a permanent parenting plan in place with AG. In an effort to appease the mother, he states it should be done very soon after she's born, but not in a fashion that stresses either of them out. He advises that he's done some reading on the topic, but doesn't want to consult a professional without AG present now. Her response is that she doesn't want to worry about that until Eliza being anywhere without her is even an option. She says there's no point in worrying about that right now. The more you bring it up, the more you stress me out. It has definitely become clear to Paul Allen that he is not the one making decisions for this child's life any longer. AG is in full control. However, he tells her, "I'd rather have something in place as soon as possible. It's important for Eliza's sake that we discuss it with a professional at some point." AG responds with, keyword, "at some point." I'm not getting anything in order that says you can have her without me before she's ready, because I don't want you taking her without me before she's ready. Please stop bringing it up. A few texts later, she says, "I do not plan on keeping her from you, so please stop trying to rush me into something I'm not ready to talk about." Paul Allen asks her to please respect how important this is for the both of them and for Eliza, and assures her they can work it out where it works for both of them. Unfortunately, in July of 2018, it's clear that Paul Allen is being phased out of the picture, and his thoughts and wishes are no longer being considered. On July 1st, AG texts him and says, "I decided I would rather her have my last name," as well as, "You want me to change my tune? I can. You want me to not even tell you when she's born? You want me to not even put you on the birth certificate so you actually do have to spend a ton of money to prove she's yours? These are all things I could do, but I don't." She follows that cold text up with, "I will still let you know when the next doctor's appointment is. I'm not going to just shut you out. I want her to have my last name, though." Paul Allen replies and says, "You're trying to push me out. This is equal. We agreed. Her name has been the same for months now." AG responds with, "What if she's not even yours and she has your last name? Because remember, that's still a possibility. So why should she have your last name if we don't even know she's yours? Paul Allen reminds her, I just bought a house with my main intention to accommodate my daughter that I don't even know is 100% mine. And I'm not saying that to make you look bad. I'm saying that is the effort that I have put in. Don't say I haven't put in any effort. I ask you constantly if you need something. She responds, and I've told you 100 times, I do not need nor want anything from you. She follows that up with another text stating, I will never forgive myself if she's not yours, and you've been so excited. Spent money on things for her, told everyone, and then if she's not, that's not a hurt I want to put you through, and I think I'm scared of the what if. He replies, I'm going to be devastated, and I will have to defend you, even in that dark time. I know you didn't do it on purpose, and if she's not mine, I'll just put those thoughts towards the future for when we do the DNA test. And I'm going to do what's right for now, which is plan to be a father. This takes us to July 25th, 2018. AG sends Paul Allen a text where she states, Paul, I'm in no place to even have a child right now. I seriously need you to get off my expletive while I figure out what the expletive I'm supposed to do. You want to help? Leave me alone. He replies, if she's mine, you give her to me. I'm more than capable. She responds by telling him adamantly that... I apologize. She responds by telling him again to leave her alone, and she will tell him when she knows what she wants to do. He adamantly tells her that he's going to back off, but no, he's not going to leave her alone, as this is his child too. July 26th, 12:14 p.m. Unbeknownst to him, this will be the very last time that Paul Allen will receive any text from the mother. He has no other way to communicate with AG, as he has no clue where she is living at this point. From this point on, Paul Allen is ghosted, completely cut off from the mother of his child. Keep in mind the baby's due date is not until September 26th, 2 months away. He continues to try and reach her via text through all of August, and then again in September. October 1st, 2018. Paul Allen, having heard nothing from the mother, sends one final haunting text. It reads simply, "Have your child yet?" There is no response. On October 4th, Paul Allen is invited to meet up with the aunt of AG so they can talk about the baby. Apparently, AG had ghosted her own family as well during the pregnancy. Her aunt tried calling AG at her last known place of employment and was advised by AG's co-worker that the baby had already been born. The news he receives from the aunt is like a slap in the face. The mother induced her labor early, and the baby was actually born on September 19th. He is stunned. Another blow is soon to follow as he receives a phone call while he is meeting with her. The call is from Martin Bauer's office. As we all know now, Mr. Bauer is an adoption attorney with multiple locations. Paul Allen is advised that baby Eliza has been placed for adoption, and the mother has already signed away her parental rights. The motion for adoption and termination of his parental rights had been filed 2 weeks earlier. They essentially asked Paul Allen when he can come by the office to sign the consent of adoption paperwork. It is literally like a punch in the gut. He makes it very clear that he is not signing the paperwork, nor is he consenting to the adoption. It is at this moment that all adoption proceedings should have come to a screeching halt when it was determined that a potential father was asserting his natural and legal right to parent his child. There should have been nothing further to discuss. Shockingly, this does not turn out to be the case, though. Over the course of the next week, Paul Allen frantically searches for and retains his first attorney. On October 11, 2018, he files a voluntary claim of paternity, even though he still doesn't know just yet if this is his child. On October 15th, he attends his first court date, where DNA testing is ordered. The results of the DNA test come back on October 24th and are conclusive with a 99.99% probability. He is Eliza's father. After 10 long months of waiting and wanting to know, Paul Allen finally has a definitive answer. On November 17, 2018, the moment he has been waiting for 11 months now, finally arrives. Paul Allen officially gets to meet his baby girl, Eliza Lee Michelle Fiscus, for the very first time. The visitation occurs at a local Wichita library. Although the meeting place is not one to be desired, he will gladly jump through any hoops required to have his daughter in his life. This includes being subjected to voluntary and court-ordered hair and urine analysis drug testing multiple times, voluntary drug evaluations at a local treatment center where it was determined he did not need treatment, mental health evaluations, depositions, and multiple court hearings. Paul Allen is now literally in the fight of his life to prove that he should have the right to parent his own biological child and not have his rights terminated completely. Between his first visitation with Eliza on November 17, 2018 and March 3, 2019, Paul Allen was granted a total of 17 visitations with his daughter. 3 other visits were canceled during that time due to bad weather. The first visits occurred in Great Bend, Kansas, 4 hours or roughly 228 miles round trip. Between December 1st, 2018 and January 26, 2019, Paul Allen made this trip 6 times to see his daughter for 2 hours, and they were supervised visits every time. The people who supervised the visits were chosen by the adoption agency, so they were clearly not there on behalf of Paul Allen, nor did they have his best interest in mind. It was prejudicial and biased, as they were essentially working on behalf of the prospective adoptive parents. Over this period of time, he was allowed a mere 12 hours of time with his infant daughter, all while under the watchful eyes of total strangers who are critiquing his every move. Later, they will testify that Paul Allen, quote, fell asleep, end quote, on multiple occasions during his visits. In reality, he was closing his eyes, smelling the sweet smell of his new baby girl, relishing in the joy of having his daughter sleep peacefully on his chest finally. He was truly savoring these precious few moments. Eventually, the visitations were moved to Garden City, Kansas, nearly 8 hours or approximately 436 miles round trip. He was now allowed to see his daughter for 4 hours on Saturday and 4 hours on Sunday, and finally, the visits became unsupervised. There was a total of 5 visits in Garden City for a grand total of 20 hours spent with Eliza between February 2nd and March 3rd, 2019. Whew. Over this time, Paul Allen took several photos of his beautiful baby girl, Eliza. Being a musician, he would often bring along his guitar and play music for Eliza and sing to her. He took multiple videos of them together while he sang. When you watch them, it sounds as if Eliza is singing along with her daddy in them. Happy as can be. Little did Paul Allen know at this time, these precious photos and videos would be all he would have to remember Eliza by. As a few short days later, the court would rule against him and terminate his parental rights unexpectedly. This is why we are here today, to right the wrongs that have occurred in this case and happen far too often in many others throughout our nation. Paul Allen's rights were terminated based on the ruling that he had failed to support the mother consistently during the last 7 months of her pregnancy, even though she had cut off all contact with him during the last 2, and regardless of the support he had provided in the first 7. With the help of his new attorney, Margie Phelps, Paul Allen has now filed a paternity for review with the Kansas Supreme Court. His life, for lack of a better term, has essentially been put on hold while he awaits the court's decision on reviewing his case. A father shouldn't have to fight strangers in court for the right to parent his own child. The potential adoptive parent's days are spent with his child, baby Eliza, who has somehow legally been stolen from him. He has missed important milestones, as he told you already. Her first tooth, her first step, her first words. This is valuable bonding time that he can never get back, yet strangers somehow are allowed to relish in it. I would now like to invite our next speaker to the podium, Miss Tana Guile.
Hi, I'm Tana, and I am the aunt of AG, and also the aunt of Baby. Until October the 4th of 2018, I did not know Paul. I had only heard things about Paul from the mother of the baby. The things that I was hearing about him were not all positive, but one thing that I did consistently hear about him was that he did want to be a father to the baby, and that she didn't have any intentions of keeping him out of the baby's life if the baby were his. She started out by telling him in the beginning that she was 110% sure that he was not the father. Then she told him a couple months later that he was the father. Then she told him that there was a 33% chance that he was the father. His rights were terminated based off of the fact that he didn't support her, but the law also discusses what's reasonable in that situation. And I don't know of a reasonable single male who had just casual relations with a female and is told that there's a 33% chance that he's the father, that would do the things that Paul did for the mother and be as involved as he was. The majority of single men in that position would have taken off, and she would have never heard from them again. They would have then been forced to be a father by the courts. Instead of Paul having to wait for the courts to force him to be a father, he went to the court wanting to be a father, and they won't let him. This baby wasn't a baby that was in need of a home. She has a home. She's a family. But she's being held by people for their own selfish needs. For no reason other than they want a baby and they feel like they're entitled to a baby. They received grant money from Catholic Charities to help pay for the adoption. That's the same organization who also approved their home study, who said that they're fit to adopt. So the whole thing, it's money. The whole deal behind all this is money. If Paul were to go today and offer them twice what they have paid for the baby, he would probably get the baby. But she's his. He shouldn't have to buy her. Babies are not supposed to be taken from their family. This baby understands biological ties. She was put into a strange room with 4 people she had never met before. The 4 people who spent 4 hours being in her face, because that was the only 4 hours we got with her. She didn't cry one time. She didn't cry until she had to go back with the adoptive family, because she knew that whole time that she was with her family. I wouldn't be supporting Paul in this fight if I didn't know for a fact that he is more than capable of taking care of this baby. If I had any doubt, I wouldn't be supporting this. If I felt like where she was at was the best option for her, I wouldn't be supporting Paul's cause. But it's not the best option for her. She's gonna hear someday that her father wanted her, that she had a family that wanted her, and that she was kept from that for people's own selfish needs. She's going to resent those people. Who wants to raise a child for 18 years knowing that when that child turns 18, she's going to do nothing but resent them and likely not want anything to do with them after that? Children want to be with their family. Children don't care who has more money. They want their family. There was so many things done wrong through the court system as well. I mean, basically Paul was just at an unfair advantage from the get-go, because he didn't have the money. Thank you.
Thank you, Tana. I know this has been a very difficult time for your family, and we are very grateful you have chosen to share how this has impacted you. Our next speaker is Izzy Gutierrez. Welcome, Izzy.
My speech is kind of short. Eliza Lee Michelle Fiscus. That name brings me to tears. It reminds me of someone I love and miss every day. She is my everything. I hate waking up every day knowing she's not with me or my family. She's with people we don't know at all. People she's going to hate when she turns 18. These people are keeping her from my family and me. We all want her. They're keeping her for her own selfish needs. And that's messed up. This baby has a loving, caring family. She doesn't need some complete strangers. There are babies that need a loving family. She has a loving family. It's stupid that Paul has to fight for his child. Right off the bat, he should have got her. There are dads out there that aren't a part of their kid's life. Paul is willing to give everything to Liza. Her mother is messed up in the head. She will pay for a tattoo before she pays for her rent. And she got her name tattooed on her and said, "Forever in my heart and on my mind, now forever on my arm." If she's on your mind so much, why would you give her up? Her mom was my best friend. I loved her, but she hurt me and she doesn't care. I just want my cousin back.
Thank you, Izzy. Whew. Most people are not aware that the state of Kansas statutes require that a father support a mother with monetary or non-monetary support for the last 7 consecutive months of their pregnancy, or they relinquish their rights to their child. Paul Allen didn't know this, but he still tried to offer support until it became virtually impossible for him to do so any further due to the mother's actions. In this case, there were 3 potential fathers involved. Does this mean that 3 men should have been giving AG monetary and non-monetary support for the last 7 months of her pregnancy? What happens in this instance to the money provided by the 2 men who are determined not to be the father? Are they just supposed to hope that the mother will return it in good faith? Or do they have to spend their time, energy, and money to file a civil suit against her to recoup the funds? Paul Allen is the only one out of these 3 potential fathers who stepped up, had any interest in this child, and provided the support to the mother, even though he didn't know if it was his child yet. In court, the mother stated she didn't feel supported by him. The court should have based their ruling on facts, not feelings. Most people are also not aware that in at least 24 states, a father must register on a putative father's registry website that focuses on the period immediately before or after the birth of the child to assert their parental rights to the child, according to the Academy of Adoption and Assisted Reproduction Attorneys website. Wikipedia describes a putative father to generally mean a man whose legal relationship to a child has not been established, but who is alleged to be or claims that he may be the biological father of a child who is born to a woman to whom he is not married at the time of the child's birth. When you register on these sites, you are required to know the current name, address, social security number, and dates of birth for both parents. If the mother and father had a tumultuous relationship and she refused to provide her information, or in the case of a one-night stand where a pregnancy occurs, how is the father supposed to obtain this information to complete the registry, especially in regard to the mother's social security number? These states and these statutes set a father up for failure from the start. Perhaps that is what the adoption industry is counting on. Unethical adoption agencies utilize many different tactics to secure a placement with adoptive parents. The adoption industry has become experts at circumventing a father's right to parent his child. Common methods include failing to secure a relinquishment or legal termination of parental rights, taking the expectant mother out of state to conceal the child and or putative father's registries, publishing due diligence notices in obscure publications, taking advantage of military deployment or assignment, listing the father as unknown, and in this case, inducing labor early or advising their client to cut off all communication with the father. Based on the fact that I am here today at this rally, you may assume that I am anti-adoption. This could not be further from the truth. Adoption is beautiful when both parents consent to it and one is not kept in the dark. There have been 2 successful adoptions in my family, and the children were placed with loving adoptive parents who have given them a great life. I personally introduced my family member to one of the prospective adoptive parents, whom I adored from the moment I met them. I knew they would love the baby as their own and would not shut out the mother from the baby's life, as it was an open adoption. They turned out to be fantastic adoptive parents, and in this case, both of these cases, everything worked out well. That is because both biological parents knew about the adoption and consented to it. Kansas statutes on adoptions and fathers' rights must be reformed. They are outdated, not clearly defined, and do not work in favor of protecting fathers' rights. Today, we propose to you the following statutes that we believe are fair and just for all parties involved. I would like to welcome Andy Daniels back to the podium to share our proposal with you.
Thank you. Thanks everybody for sticking with us. This is obviously a very passionate subject for all of us. Took a lot to get this together, to get speakers out here, to get everybody involved, and we just hope that as 2020 goes forward, that you guys will start having conversations. Have conversations about adoptions. If you know someone who's adopted, ask questions. Have conversations. Just make sure, let's hold each other accountable, and let's make sure that we do this right, and we encourage people to do it right from here on out. The goal should be family preservation in whatever sense we can make that happen. I'm going to read some of the proposed statutes. Hopefully some of the Kansas legislators will get a hold of this and seriously take into consideration our proposals. One thing that I do want to reiterate that Paul Allen mentioned is the Family Law Advisory Committee here in Kansas is made up of adoption attorneys who will only work for adoptive families and the probate judges who decide these cases. The legislature takes the recommendations of that committee and turns those recommendations into the law. If you guys back here in this building behind me can maybe find some community advocates, heck, put Paul Allen on that committee. He'll have some good suggestions for you. He might go toe-to-toe with some of the other people, but at least it'll be fair. We'll have some representation. Here are some of the statutes that we would ask that you assert in the Kansas adoption statute to ensure protection for both birth fathers and birth mothers, what I like to call first fathers and first mothers, equally in regard to adoption. First, a pregnant mother who has decided to relinquish her parental rights ought to be required to notify all prospective fathers of the pregnancy and notify all prospective fathers of the decision to relinquish her parental rights. Putative father notification, as Sharon just explained, should take place at least 3 months prior to the expected date of birth of the child. This gives ample time for the fathers to respond, not after the adoptive parents walk away with the baby. Immediately upon making the decision to relinquish parental rights to the unborn child, if less than 3 months prior to the birth, but should not be more than 24 hours following the birth of the child and should occur before any potential adoption filing may proceed. And I would add that the notification should happen before the potential adoptive parents take physical custody of the child. In cases where the mother claims that she does not know who the child's father is, the statute currently assumes that the father should be aware of a possible pregnancy because he had sex. It is therefore assumed, or it should be assumed, that the mother ought to be aware of the name of any and all individuals who have potentially fathered the child because she had sex. For the purpose of this statute, it should be assumed that the mother and father are equally responsible for the pregnancy and all ramifications or notifications thereof. Failure to inform the unborn father's child of the pregnancy and or the impending adoption of his unborn child within the aforementioned time frame should be grounds for immediate termination of any impending adoption proceeding unless the father consents to the adoption proceeding after the fact. Do you see what we're getting at, guys? You shouldn't let strangers come and take the baby away before everybody's had a chance to be notified and agree. Prior to the physical birth of the child, the law provides protections for the right of a pregnant woman to terminate a pregnancy. However, the moment the mother delivers the child, the father's right to parent the child should be immediately protected as well. The law provides constitutional protections for the right of a father to parent his child. It is rightly assumed that the father is equally and fully capable of parenting his child. The mother's decision to relinquish her rights should not infringe upon the father's parental rights, which should remain fully intact. And remember, currently, if a mother relinquishes her rights and gives the baby up to the adoption agency, the father then is presumed to have no rights until his day in court, which may be months later, including physical custody rights. If the mother chooses to relinquish her parental rights following the birth of the child, the father is fully within his right to choose to keep and parent the child. Under no circumstance shall it be assumed that the father has no interest in parenting the child purely because the mother has not decided to parent the child. Guys, this is the cultural legacy of unwed fathers. You might buy into the narrative that fathers don't want to be involved. And I would encourage you, if any of you are sociologists or if you guys know anybody who's a sociologist, I want to see more research about the impact of fathers not getting to father their children. There's not enough talk about it. There's not enough studies about it. But I can guarantee you a lot of these guys probably have something to say in a very emotional way about it if somebody would just ask. Under no circumstance shall the father be required to prove fitness to parent his child over and above the proof which is required of the mother and or prospective adoptive parents. If all they have to do is invite someone to their house and say, yeah, you have a crib, yeah, you put plugs in the walls, why is that? Why is more required of the father? If either parent asserts his or her right to parent the child less than 30 days following the consent to adopt the child, all the adoption proceedings must be immediately terminated. The physical custody of the child must be returned to the parents and a reasonable parenting plan put into place without undue delay. See, it's a vicious cycle because the adoptive parents get to take physical custody and then it's an uphill battle from there. And as we've seen from Paul Allen's case, that uphill battle is anything but guaranteed. The prospective adoptive parents must relinquish physical custody of the child immediately if consent to adopt the child was obtained less than 30 days prior. They have no legal standing. At no time shall the attorney for the prospective adoptive parents be allowed to file a petition in court to demand either natural parent prove they are fit to parent their child. The prospective adoptive parents have no legal standing to make demands of either parent. If consent to adopt the child was obtained over 30 days prior, the adoption should be finalized. The statute currently reads that if a father desires to preserve his parental rights following the birth of a child he has fathered, who the mother has determined to adopt, then the father has a responsibility to maintain contact with the mother in order to support the mother financially throughout the final 7 months of pregnancy. The failure to support statute has been utilized numerous times to terminate the rights of an interested parent, despite attempts being made to provide support. This is a catch-22, and it's a catch-22 of the most obvious means. Don't tell the dad that the mother's pregnant. Don't give him the opportunity to support. And then once that window has passed, then blame him for not doing so. Especially don't educate any potential dads. What, is there a high school class about what to do if you're an unwed dad? Well, maybe if there were, we wouldn't be in this issue. The statute must state that the mother has a duty to allow the father access to information regarding the best way to provide her the support she requires. The birth mother must be willing to receive support from the father of the unborn child. In cases where the mother has decided to disengage from communication with the interested father, the potential father financial account of some kind could be created. However, we would need this to be statutorily allowable because right now, in the United States, you cannot go open a bank account for another person. The best you can do is a transfer on death. Courts have previously ruled that the mother's refusal to accept support from the father of an unborn child does not nullify the parental rights of the child. The fact that this is even being brought up in court now just bespeaks the patchwork nature of this process. Refusal of the unborn child's mother to maintain contact with the unborn child's father, or refusal of the unborn child's mother to communicate with the unborn child's father, should not nullify a father's parental rights as it pertains to support of the mother during the pregnancy. Documented demands from the unborn child's mother to the child's father, either that she does not need or does not want his financial support, should not nullify a father's parental rights. The father should not be required to make undue overtures in order to convince the mother to accept the support, and refusal of the unborn child's mother to accept support should not be grounds to terminate the father's rights. Attorneys who specialize in arranging adoptions are assumed to be working in the best interest of the child. Therefore, it is incumbent upon these attorneys to consider the wishes and desires of all interested parties, including the unborn child's father, before moving forward with an adoption. You know, a neat trick that I've noticed that the adoption attorneys will do is that they'll start out with the best interest of the parents, and they'll try to argue fitness of the parent. And that usually takes long enough, 2 years in Paul's case, that then they can argue that it's in the best interest of the child to be able to stay with that adoptive family. Once again, we have a catch-22, circuitous logic, and it's all wrapped up neatly with a bow with the holes in the legislative scheme. Attorneys representing parties in adoption proceedings must make any prospective adoptive parents aware of an interested father who is likely to contest an adoption at least 3 months prior to the birth of the child or within 24 hours of being made aware of the father's interest. The law currently holds that a birth mother may not be asked to sign final adoption paperwork until 12 hours have passed following the birth of the child, with some exceptions. This same 12-hour rule should hold true for the father. Attorneys should obtain pre-adoption consent from the birth father. The statement should be included with the original petition, and like the mother, the father ought to retain his right to withdraw consent for 30 days. I would add that the legislature seriously consider extending the time frame that a mother can consent to relinquishment. At least 24 to 48 hours. 12 hours is not long enough. If the mother or father chooses to withdraw his or her consent for any reason, it is grounds for termination of the impending adoption proceeding. It should be assumed that the best interest of the child when mother, father, and prospective adoptive parents are in agreement about the adoption, but each individual interested party has rights that should be protected separate from one another. No attorney who specializes in adoption should represent more than one party in the adoption proceeding. The mother should have her own attorney of her own choosing, not chosen by the adoption agency that's run by the law firm that does it. I'm just saying, that lawyer that you guys hire for the mom, who also is an Amazon author and travels to France all the time, probably not a real lawyer for the mom. Probably not going to do that great of a job. You just have somebody to sign paperwork for her, that's not good enough. The father should have his own attorney, and the prospective adoptive parents should have their own attorney. And the prospective adoptive parents ought to be responsible for payment of the attorneys of all parties. If you want to go in with your $50,000 that you made, then you need to pay for the process. Excluding decisions related to the direct care and well-being of the child in their physical custody, at no time may the prospective adoptive parents make further legal decisions related to the child until such time as the adoption is finalized. And the mother and father of the unborn child are assumed to have equal legal authority to make decisions in parenting their child. These are the explicit statements that should be lined out. And I'm sure there's many more. I'm sure there are very smart legal minds who are not financially involved and financially incentivized to have adoptions just go through, who can weigh in. But this is from Paul Allen's experience. This is what would be necessary. These are things that the Kansas State Legislature should seriously consider looking at and discussing with both pro-adoption and pro-father attorneys. Sharon, you ready?
Thank you, Andy. In conclusion, we would like to say thank you to everyone for your time today and for attending our rally for FreeEliza, a father's rights organization. We sincerely hope that our voices have been heard today and that change will occur in the laws regarding adoption and parental rights in Kansas and throughout the nation. We will continue to fight for Paul Allen's natural and legal right to parent his child, Eliza Lee Michelle Viscus. We are also available for personal interviews immediately following the rally. Thank you.